All right, so thank you for joining me for the second webinar of this online course on protection of stateless persons. And the topic for today's webinar relates to the themes from week 3 onwards, which is prevention and reduction of statelessness. As we discussed in the in the previous webinar, but also as I wrote in my instructor's message, the protection of stateless persons regime is quite different from the regime for protection of refugees in at least one sense. That in case of refugees, while the regime focuses a lot on excuse me, on protection of the rights of refugees, granting them asylum, social welfare provisions, durable solutions, etc., etc. The refugee regime doesn't logically and for practical reasons focus as much on issues of preventing the refugees from emerging in the first place. And this is for practical reasons, particularly given the fact that it is difficult for the UNHCR or the UN architecture in general to prevent conflicts, for instance, emerging in the first place. Not that there's not been written much about how early warning systems can help do that, but in reality, we know that it's much more difficult and non-feasible for the United Nations, particularly the UNHCR, to prevent refugees from emerging in the first place. So that's not the case, however, in case of stateless persons. While the 1954 convention, as we saw in the first webinar, focused on the status of stateless persons and protection to them, it is in fact possible outside of that context to prevent and reduce statelessness. So that is dealt with in the 1961 Convention on the reduction of statelessness, because when the 1954 Convention was adopted, pretty much on lines of the 1951 Refugee Convention, it soon emerged, a realization soon emerged that we can actually reduce statelessness as well, predominantly by focusing on two things. One is guaranteeing acquisition of nationality to individuals both at birth and later. And the other side of the equation is preventing the loss or deprivation of nationality under any circumstance, not to lead to statelessness by deprivation or loss of nationality. So the idea was to create regulations and rules around the acquisition of nationality and also prevention of loss or deprivation of nationality. So the strategy to deal with statelessness will never succeed if we focus only on protection, and hence the 1961 Convention, which aims to create an international normative framework for reducing the problem of statelessness. So to begin with, I think it's always important to talk about the human rights regime related to the right to acquire a nationality. And this is related, this is incorporated both in the Convention on the Rights of the Child, but also in the International Covenant on Civil and Political Rights. Now, importantly, both of these conventions, the ICCPR, of course, is one of the most important of all human rights treaties, but also the Convention on the Rights of the Child, both were adopted and came into force much later than the 1961 Convention on the reduction of statelessness. So a lot of these provisions here are drawn out of the legal framework that the Statelessness Convention in 1961 sought to achieve. So the key provision in both these human rights treaties is that every child has a right to acquire a nationality. Now, going back to 1961, of course, the convention also, as I'll point out through a review of the provisions that we will undertake in this presentation, this 1961 convention also focuses a lot on ensuring acquisition of a nationality by children, because that is the clearest way of preventing statelessness from emerging in the first place. So in the Convention on the Rights of the Child, which is much more elaborate than the ICCPR, there is Article 7, which is central to our discussion. It says that the child shall be registered immediately after birth and shall have the right from birth to a name, the right to acquire a nationality, and as far as possible, the right to know and be cared for by his or her parents. So to our discussion, obviously the central part here is the right to acquire a nationality. This is a guaranteed right to all children, irrespective of where they are. Now, one thing that I should point out is that you will find here the human rights regime, particularly the regime for the rights of the child under this convention, complements the 1961 Convention on Reduction of Statelessness, but in a much stronger manner than, let's say, human rights treaties would complement refugee protection. I'm drawing a parallel there. This is because the 1961 Convention, which also has a lot of rules relating to acquisition of nationality, etc., is ratified only by 77 countries in the world. So it's very under-ratified. In contrast, or by contrast, the Convention on the Rights of the Child is the most ratified of all human rights treaties. In fact, there is only one country that has not ratified the Convention on the Rights of the Child. Anyone wants to take a guess which country that is? I see Carolina has joined, Azin, Lara, and iPhone SCB. I'm sorry, I don't know who that is, but
sorry, that's me, Sophia Cobb. That's my
okay.
iPhone.
All right, Sophia. Anyone wants to take a guess who's which is the only country in the world that has not ratified the Convention on the Rights of the Child?
United States.
That's right. It's the United States of America. US is the only country in the world that has not ratified the Convention on the Rights of the Child, and for many reasons. And in the Q&A session later on, we can discuss on if you are so inclined, on what the reasons are and what the implications are for US not ratifying it. But the larger point I'm making here is that the Convention on the Rights of the Child and the right to acquire a nationality goes much beyond in its impact than the 1961 convention, sheerly because of the wide ratification of this convention. So this right is guaranteed to almost every citizen, every child on the planet, okay, simply by virtue of the CRC. Now, every time there is a right in international law, as you know, there is a corresponding duty. And typically in human rights treaties, that duty tends to be on states. Not that states are the only duty bearers of human rights. There are others as well, but typically the principal obligation lies on states. So paragraph 2 of Article 7 stipulates that states parties shall ensure the implementation of these rights in accordance with their national law and their obligations under the relevant international instruments in this field, in particular where the child would otherwise be stateless. So I want to pause here for a second. Clearly, this is a corresponding obligation on states parties to the rights of the child to acquire a nationality. Now, what is key here, the key terms here in this paragraph are if the child or where the child would otherwise be stateless. Now, as I take you in the coming slides through the 1961 convention and its scheme, we'll point out that the entire structure of the 1961 convention applies, all the obligations apply only if the child would otherwise be stateless. Okay, so the 1961 doesn't really oblige countries to a particular form of nationality laws. It doesn't mandate a particular form of nationality laws, nor does it require a conferral of nationality under all circumstances. The only circumstances where those obligations step in is if the child would otherwise be stateless. This is a central part about the statelessness regime and the right to acquire nationality that is guaranteed to all children under the Convention on the Rights of the Child, but also under the 1961 Convention on Reduction of Statelessness. So another very important provision that runs like a golden thread, I would say, throughout the Convention on the Rights of the Child, binding together all its provisions, is the best interest of the child. This concept is extremely important, the best interest of the child. And it stipulates here in Article 3, for instance, that in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interests of the child shall be a primary consideration. Okay, so whether we look at provisions relating to custody of children, provisions relating to just general welfare, schooling, um, administrative procedures, legislations on children, the central theme is what is the best interest of the child, and this is the primary consideration. In fact, when we do trainings of judicial officers or police on how to deal with children, juvenile offenders, for instance, etc., etc., even in custody matters, there are very set techniques for how to conduct a best interest of the child determination procedure. Okay, so there are techniques for doing that, and it's a very well developed field of expertise on how to identify what the best interest of the child is. All right, now let's come to the 1961 convention, which is the central convention on reduction of statelessness. And I'll begin with first pointing out that this convention does not define the term stateless. However, considering the fact that it's part and parcel of the or sequence in sequential order, it follows the 1951 convention. The definition of stateless person is exactly understood to be the same as the 1954 convention, for the purpose also of the 1961 convention. And as we have seen extensively in various debates, both on the forum and in the webinar in the first webinar, the 1954 convention defines a stateless person as someone who is not considered as a national by any state under the operation of its law. This is de jure statelessness. And this definition is considered to be customary international law. This has in fact been, the statement that it is customary international law has been recognized by the International Law Commission as well. Okay, so for the 1961 convention, it's exactly the same definition that follows. Now, as I pointed out earlier, the strategy of the 1961 convention is not to dictate to any of the states parties the basic rules according to which nationality must be granted or withdrawn by states. It says nothing about mandating, making certain set of rules obligatory on states. What does this mean? It means that even with relation to acquisition of nationality, the 1961 convention does not impose upon states a particular regime such as jus soli, whereby states grant nationality to all countries born in their territory, nor does it impose the adoption compulsorily of a jus sanguinis system, whereby citizenship is conferred or acquired by descent from the nationality of the parents. So the 1961 doesn't do any of this. In fact, it to my mind at least, it provides a huge amount of latitude to countries to determine whatever regimes they want to adopt with relation to acquisition of nationality, but also in case of a certain amount of latitude also in case of loss or deprivation of nationality, which has been criticized. I'll point out those criticisms related to loss or deprivation of nationality and how liberal this convention is with relation to that as well. But the basic point I'm making here is that it doesn't impose a particular type of regime. Why is that the case? Because as I pointed out earlier, all the rules of the 1961 convention kick in only and only if a person would otherwise be stateless. Only if that is the scenario, then the obligations under the 1961 convention step in. So there are a few obligations that are key to understand in the 1961 convention. The first is that it requires that in instances where an individual would otherwise be stateless, the state in which the child is born grants its nationality to prevent statelessness. This is the very first article of the 1961 convention. Again, the key word here is if the child would, or if a person would otherwise be stateless. So countries are not mandated under this convention to mandatorily, compulsorily grant nationality under any regime. This obligation steps in only when two circumstances are fulfilled. Number one, the state in question is a party to the 1961 convention, so one of those 77 countries. And even then, if the person would otherwise be stateless. Okay, so in this case, what the provision says is if the child would otherwise be stateless upon birth in a country that's a party to the 1961 convention, then that state where the child is born must grant nationality to prevent statelessness. Circumstances surrounding these instances can happen in many cases. If you recall, in the first webinar, I gave you the example of India, which is a jus sanguinis system. No one born on Indian territory to foreign parents is conferred Indian nationality. So I gave you the example of German parents, second generation Germans giving birth to a child in India. The fact that they are born in India wouldn't mean that the child gets nationality. And according to German laws, after a couple of generations, if you've stayed outside of Germany, Germany also doesn't grant nationality by jus sanguinis. So that child would otherwise be stateless. But India is not a party to the 1961 convention. Therefore, although the requirement of the child otherwise being stateless is fulfilled, India would still not be obliged to confer nationality. If India were a party to the 1961 convention, in that case alone, India would be obliged to confer nationality to the child of second generation or first generation German parents who are born, when the child is born in India. Now, this is not the only circumstance. We have had instances, a lot of instances, for example, of statelessness emerging in Bangladesh because of simple discrimination. I mean, if the provisions of the Bangladeshi constitution and local laws are read correctly, Bangladesh should be obliged to grant nationality to people born on their territory in such circumstances. But there has been rampant discrimination in application of those laws, including misinterpretation of the constitution of Bangladesh by all actors in Bangladesh. But that would be a good circumstance to indicate where a child would otherwise be stateless. I mean, I'm talking here about the children of Rohingya parents, of Rohingyas born in Bangladesh after having fled from Myanmar. Myanmar is not granting them a nationality, nor is Bangladesh granting them nationality because they have been born, children have been born in Bangladesh. And these would be otherwise stateless. If Bangladesh were a party to the convention, then this provision would kick in and it would have to grant nationality. And that's why this convention, which is under ratified with only 77 countries, if more widely ratified, would resolve a tremendous amount of issues in the context of reducing statelessness. Now, Article 4 is the counterpart to Article 1, which says that in the event that a child is born to a national of a contracting state in the territory of a non-contracting state, a subsidiary obligation comes into play, and the state of nationality of the parents must grant its nationality if the child would otherwise be stateless. So in the India-Germany example that I have been giving you for the sake of consistency since the first webinar, let's say if the child would be stateless in India because India is not a contracting party. If Germany is a contracting party, then because the parents have the nationality of Germany, irrespective of the intergenerational rule, if Germany were a contracting party, then Germany would have to confer nationality on the child. Okay, that's Article 4. So if the country where the child is born is not a party, then the country of the nationality of the parents must confer nationality. Again, all of this only in case if the child would otherwise be stateless. All right. Now, this is something that I have found extremely useful. In fact, there's a bit of a history behind this chart. It's developed by me. And this is because when I read the statelessness, reduction of statelessness convention, the first time many years back, I found it extremely difficult and not easy to understand the scheme of the convention with respect to acquisition of nationality by children. So I'm going to divide this rest of the presentation into two parts, where we are now dealing with the rules relating to acquisition of nationality. And then there are the other side of the equation is the rules relating to loss or deprivation of nationality. We'll focus on acquisition of nationality. Now, as I pointed out, the provisions are extremely cryptic. It is very difficult to make logical sense or to paint a clear, coherent picture of this. So I undertook this task many years ago to put everything into a schematic flow chart. And I have personally found this very helpful, and so have many of my students over the in the past found this very useful to make sense of the scheme. So there are two main scenarios we are talking about here when we analyze the rules of the 1961 convention with respect to acquisition of nationality by children. Scenario one is in case where the child is born in the territory of a contracting state. That is, the state where the child is born is a party to the 1961 convention. That's one scenario. The second scenario is where the child is born in territory of a non-contracting state, but to parents of a contracting state. Okay, so these are two separate circumstances, and there are different sets of rules that the 1961 convention lays down or stipulates relating to acquisition of nationality. Now, I'm going to go one by one. Let's go first to the scenario where the child is born in the territory of a contracting state. Again, here, there are two separate circumstances that emerge. The first is, I'll go with the second one first, which is, let's say the mother belongs to the contracting state. Okay. And this is very important to highlight in the context of this convention, because there are circumstances where countries are deeply patriarchal in their acquisition of nationality laws. Some of those examples are in your readings. There's a whole analysis of that I think in week 4 or 5 we are going through. So what this provision says, well, some of those laws in fact say that nationality, even if the child is born in the territory, the nationality would be conferred only from the father. If the mother happens to be a national, but the father is not a national, then the child doesn't automatically get the nationality of the country where the child is born. There are examples of this, for instance, Saudi Arabia, some other countries in the Middle East where nationality is not conferred on the basis of mother's nationality. So let's say a Saudi mother, but the father is from Germany or Italy. The child is born in Saudi Arabia. Acquisition of nationality is not automatic according to Saudi laws. In fact, the child has to wait till the age of 18 to attain majority in Saudi Arabia to file an application for nationality, and that too under very strict circumstances and the regulations involving that including that the child must speak Arabic, the child must have lived in, must have a status of permanent resident of Saudi Arabia, etc., etc. So they're pretty strict requirements. So to avoid all of those circumstances, what the 1961 convention says is that if you are a state party and the child is born on your territory, the father happens to be a national of another country, should not matter. If the mother belongs to the contracting state, nationality of the child should be automatic. You shouldn't require, like Saudi Arabia, for instance, having the child wait till the child turns 18 and becomes an adult and then impose other additional requirements on it. The nationality of the child should be automatic, even if it flows from the mother. So that's a very important provision, which by itself could take care of a lot of statelessness issues that tend to happen in countries like Kuwait, Saudi Arabia, UAE, which are, you know, pretty decent hotspots for statelessness as well. Now, the other circumstance where the parents are from other states, both parents belong to other states. This is the more common scenario that we often find, for instance, in countries in the context of, Myanmar, for instance, which is one of the biggest hotspots today, or other countries like DRC, Burkina Faso, Zimbabwe, etc., where both parents are from other states. Here again, the 1961 convention, in the spirit of not imposing a particular form or regime on states, again gives options to countries. Okay, so there are two options that countries can adopt in terms of the laws that they want to have in order to deal with the problem of statelessness because of non-acquisition of nationality. The first is a scenario where countries can have laws, that are states parties to the convention can have laws where they can say that, well, we will confer nationality at birth simply by operation of the law. So no application required. The fact that you're born on the territory and you're otherwise stateless, your parents are not from this country, we will have a law which automatically confers nationality on the child. This is what is in Article 1, Paragraph 1, subparagraph A. And you will see that if you kind of read the provisions just in the bare text of the treaty, you'll be completely lost. And that's why this kind of putting everything together in a flow chart is very helpful. But countries are not obliged to have such laws that automatically confer nationality at birth. They can also have a system where acquisition of nationality can be by application. So applying for nationality, and such national applications can be filed by parents from other states on behalf of the child who is otherwise stateless, born on the territory of a country that is a party to the 1961 convention. So again, here, two circumstances. Number one, where the time period is prescribed by the state concerned for when the application can be made, along with some other conditions. So the convention allows countries to prescribe a maximum time period within which the application for acquisition of nationality must be made, and beyond which no application would be considered. So the presumption here is that if a child and the parents have lived in a country for some time, then they can't postpone indefinitely the application for acquisition of nationality. They must avail of this opportunity at within a particular time. In addition to the time limitation, the convention does allow countries to prescribe other conditions if they so choose to do. So what are those? Number one, the convention says that if you prescribe a time period, countries must allow applications before 18 years of age and must keep the option open at least till 21 years of age. Countries can keep it much beyond 21 also, but at least till 21, the option of filing an application for acquisition of nationality must be open. Why at least till 21? Why not cut off at 18? Because many times a child has no agency of his or her own in many domestic legislations around the world, where children before the age of 18 must file applications, for instance, through their parents. And therefore, the idea is once a child has become 18 and has the agency according to many of the domestic laws of countries around the world, and I say many because some countries do permit agency even before 18, but many don't. So the child should have at least 3 years of adulthood to make a decision of her or his own to file the application for acquisition of nationality. Therefore, the option must be open at least till 21, but of course you can go much beyond as a state if you want to. The convention also says that the states must not require habitual residence for more than 5 years immediately preceding application. So 5 years is the maximum you can go to, and not more than 10 years in total. Okay, so countries can require habitual residence conditions to be satisfied, but those must be within the limits of what the 1961 convention says, which is that immediately preceding the application, please don't insist that you must have been a habitual resident for more than 5 years. And if you are not looking at immediately preceding but total numbers of residents, then don't require such residence for more than 10 years, because that is unnecessarily putting limitations on the possibilities for children or persons in this situation to acquire nationality. It also says that countries can require that there should be no sentence because of an offense against national security, or sentence to imprisonment for a term of 5 years or more on a criminal charge. If there are such sentences, then the convention says that we are not going to force countries to confer nationality on someone who's otherwise stateless. Countries, if they so choose, can determine that they don't want to confer nationality to a person who's been sentenced to serious crimes. Okay, that's one scenario. Now, let's assume that a country has prescribed the time limit of 21 years, but the person has not filed an application before the age of 21. What happens if the time period is over? Then the convention provides a subsidiary option. It says in that case, the application can be made to the state of nationality of parents if they are also from the contracting state. Okay, now this option applies only if the country of the nationality of parents is also a contracting state to the 1961 convention. So we are really limited among 77 countries where these rules apply, right? And here also the convention says that, well, such countries can also adopt certain conditions. They can have certain requirements. For instance, they can prescribe age limit for application, but not less than 23 years. Again, the idea here is that after the age of 21, they should have at least 2 years to make an application to the country of nationality of the parents. Of course, countries are allowed to have more age limit than just 23 years. They can go up to anything that they want if this scenario is to apply. And countries in such circumstances must not require habitual residence for more than 3 years for the application to be successful. So this is the regime that the 1961 convention stipulates with relation to child born in the territory of a contracting state. Now let's say come to the other scenario, which is that the child is born in the territory of a state that's not a party to the 1961 convention, but the country of the nationality of parents is a state party to the 1961 convention. So in case we are talking here, let's say Germany is a state party, India is not, and the child would otherwise be stateless in India, then Germany has two options here, again, by virtue of the convention. Germany can have laws where nationality is conferred by operation of law automatically, or Germany can say, well, yes, we guarantee you nationality, but you must apply. Okay, and even here, in case of application, the 61 convention says that countries can impose certain requirements for that. For instance, they can prescribe age limit for application, but this must not be less than 23 years. They must not require habitual residence for more than 3 years. And they can require that there is no sentence because of an offense against national security, let's say in this case of Germany. So this is the scheme with relation to the other dimension, where only the country of nationality of parents of the child that's otherwise born stateless is a state party to the 1961 convention. Trust me, if you read the provisions of the convention just on their own, this really becomes cryptic. But I hope that this chart, which also has been uploaded on the course site, helps decipher, unpack, deconstruct the convention in a much more accessible manner for all of you. All right, now other important provisions of the 1961 convention, two of them I'd like to highlight in terms of acquisition of nationality. One is Article 2. It says a foundling found in the territory of a contracting state shall, in the absence of proof to the contrary, be considered to have been born within that territory of parents possessing the nationality of that state. So whenever a foundling, a baby is found on the territory of a contracting state and it's not known who the parents are, then unless there is some proof to the contrary, that foundling will be considered, will be assumed to have been born on the territory of that state to parents that possess the nationality of that state, in which basically is a provision aimed at ensuring that that a foundling that is just found on the territory of a contracting state will automatically be conferred nationality of that state. Then Article 3, for the purpose of determining the obligations of contracting states under this convention, birth on a ship or in an aircraft shall be deemed to have taken place in the territory of the state whose flag the ship flies, or in the territory of the state in which the aircraft is registered, as the case may be. As you're all aware, ships and aircrafts need to be registered in a particular country, and the place where they are registered is the flag that the ship or the aircraft carries. Many of the ships, commercial ships, for instance, are registered in Cayman Islands, Panama, etc., etc. So it's those countries are the flags of which those ships bear the nationality they carry. In case of aircrafts, it's simpler than that. Turkish Airlines, for instance, is registered in Turkey. And so Turkey will be the flag that Turkish Airlines carries. Now, what this provision says is that, again, this applies for the purpose of determining the obligations of contracting states under the convention, which means if the child is otherwise stateless. So if a child who would otherwise be stateless is born on a ship or in an aircraft, then the country of which this ship or the aircraft carries the flag will be the country that must confer nationality to the child, but again, provided that that country is also a party to the 1961 convention. So these sorts of circumstances are very rare to happen. Not that they haven't happened. They probably have happened in case of merchant navies or merchant ships, more perhaps in the past. But when I say that circumstances where this provision would apply would be rare, are because, number one, you would need to have a circumstance where the child is otherwise stateless, which means that it's a country which doesn't accept jus sanguinis, which is very rare by itself, right? Because, I mean, we know that countries that have jus sanguinis system don't necessarily have jus soli, but countries that have jus soli system also parallelly tend to accept jus sanguinis system. So Costa Rica, for instance, is a jus soli system. Anyone born in Costa Rica is a Costa Rican citizen. But Costa Rica also allows for jus sanguinis, which means that if Costa Rican parents give birth to a child elsewhere, anywhere in the world, then Costa Rica also recognizes nationality for that child by descent from parents. So these sort of circumstances where a child would otherwise be stateless, born on a ship or an aircraft, are going to be very rare, because most countries do accept jus sanguinis for children born outside anywhere also. But more importantly, you would also need to have a circumstance where that country that carries the flag is also a party to the 1961 convention. So many circumstances play into the applicability of this particular provision. Birth of children on ships or aircrafts are not rare. That happens, right? I mean, we often, at least once or twice every year, there are news reports of some child born on an aircraft, and many stories of children born on ships. But this sort of circumstance where the child is otherwise stateless, as well as the country carrying the flag is a party to the convention, all of these combinations to happen are indeed rare. But should that happen, this provision is very important. All right, now let me turn my attention briefly to the provisions relating to loss or deprivation of nationality. These are captured in Articles 5 to 8 of the 1961 Convention, and they establish the basic rule that loss or deprivation should not cause statelessness. So if you're party to the 1961 Convention, you are prohibited from depriving someone of their nationality, generally speaking, as a matter of principle, if that would result in statelessness. So where the 1961 Convention requires that a person shall not lose or be deprived of nationality if this would render him or her stateless, states are required to examine whether the person possesses another nationality at the time of loss or deprivation, not whether they could acquire a nationality at some future date. So two things here. If you are a party to the Stateless 1961 Convention, anytime a decision is to be made relating to loss or deprivation of nationality, there is an obligation on that state to additionally conduct an examination whether that person would otherwise be stateless. Okay, which means you have to examine if that person possesses another nationality. Now, in temporal dimension, when is it? What is the moment at which the possession of another nationality is determinated? And what the 1961 Convention clearly stipulates is that the moment of possession of nationality of another country that you must consider is at the time when you are making the decision of loss or deprivation of nationality for that person, not whether that person can acquire a nationality at some future date. So if there is a chance that a person, I have to make a determination as a state to deprive a person of a nationality or have him lose his national or her nationality, I can't do so if I'm a party to the 1961 Convention. I can't do so on the argument that this person in 5 years, because this person has been living somewhere, will be eligible for nationality of that particular country. That is not allowed, okay, because I'm actually rendering that person stateless for at least 5 years then. So the point at which the decision must be made or determination must be made whether that person possesses another nationality or not is at the time when I, as a state, am determining whether that person should lose or be deprived of nationality. So very important provision in order to avoid an limbo situation where at least for a particular point of time, a person may be rendered stateless because of loss of nationality. That should not happen, and hence this very important scheme of the provisions. So in terms of determination of non-possession of other countries' nationality, the provisions say that a contracting state must accept that a person is not a national of a particular state if the authorities of that state refuse to recognize that person as a national. So again here, like the 1954 Convention, it is not what the person himself or herself says. That's not determinative. It's not even what I as a contracting state say when I'm making a determination of whether my citizenship should be deprived. It's not for me to sit in judgment over the determination of whether that person is a national of another state or not. We have to rely on that other state's authorities and their determination. If they say this person is not a national or not a national, then obviously a contracting state must immediately accept that. With the same logic is the next provision, which says a contracting state cannot avoid its obligations based on its own interpretation of another state's nationality laws, which conflicts with the interpretation applied by the other state concerned. So if another state says that, well, actually this person is not our national, we immediately must accept that. We can't come back, we can't go back and say, look, we are going to interpret your laws, and according to our interpretation, that person is your national, even if you say no. Such a scenario is not permitted under this convention. What is important here and what is the sole requirement is that other country must say that we do not recognize this person as a national. in which case, if I'm a state party, then I am prohibited from depriving nationality in general to this particular person. All right, now, very importantly, there are certain structural lacunae in the provisions of the 1961 Convention related to loss or deprivation of nationality. Acquisition laws are very good, but some of the provisions related to loss or deprivation have been pointed out as a voice from the past and not really relevant in today's world. So in your readings, I have included, I think in the optional material, the Tunis conclusions. The Tunis conclusions are to the 1961 convention what the Prato conclusions were to the 1954 convention. So again, a group of experts convened by the UNHCR to analyze the 1961 convention. Of course, the Tunis conclusions have now been converted by the UNHCR into elaborate handbooks and guidelines, which are also part of your required readings actually. So you'll find a lot of this there. But in the Tunis conclusions, the group of experts concluded that some of the provisions of the 1961 convention are redundant or not relevant or counterproductive in today's world. So I'm going to give you two examples of that. One is Article 7, paragraph 4, which stipulates that a naturalized person may lose his nationality on account of residence abroad for a period not less than 7 consecutive years, specified by the law of the contracting state concerned if he fails to declare to the appropriate authority his intention to retain his nationality. Now, in the past, this probably might have made sense, but in a globalized world where people are all the time on the move, this sort of provision may be detrimental, especially if people simply don't know that such laws may exist. For instance, my son was born in Azerbaijan, but has naturalized into a Costa Rican citizen, having lived here in Costa Rica since the age of 8. He's now 19. Obviously, Costa Rica is a country which has no military, which abolished its military. So he's grown up in that context, whereas Azerbaijan has compulsory military conscription. And so obviously for someone like my son who's grown up in an atmosphere where it's not a militaristic country at all, peace and peace is part of the lifestyle of people here. The touch with the Azerbaijan as the country of birth was completely lost. But let's say that he naturalized as a Costa Rican citizen, but of course he may not live in Costa Rica for all his life. He may work abroad, he may go abroad. What this provision says is that if he has lived abroad as a naturalized Costa Rican citizen, if he's lived abroad for 7 consecutive years, then he may lose his nationality on account of that, if he fails to declare to the appropriate authorities of Costa Rica his intention to retain his Costa Rican nationality. As I said, probably in the past this might have made sense, but these days the number of people who live abroad, even after naturalization in another country on account of work, on account of whatever, is so much. It's so much of so many people living abroad that it's easy to miss out on such requirements if they exist. People may not even know that such requirements are imposed by their countries. And so the Tunis conclusions pointed out specifically that, look, there is a problem in such kinds of provisions, and they are probably a voice from the past. Something needs to be done about them. And another example is Article 7, paragraph 5. In the case of a national of a contracting state born outside its territory, the law of that state may make the retention of his nationality after the expiry of 1 year from his attaining his majority conditional upon residence at that time in the territory of the state or registration with the appropriate authority. Again, here in a moving world, in a world which is so globalized, having laws which make retention of nationality conditional upon such residence it may not be workable in or relevant in today's time. So Tunis conclusions take exception or to such provisions, and I generally agree that these provisions in the 1961 convention are probably a voice from the past. All right, now I pointed out that this convention is under ratified. Of course, if the majority of the world ratifies the 1961 convention, the problem of statelessness would be dramatically reduced as compared to where it is today. And we are still talking about anywhere between 10 to 13 million people around the world being stateless today. And again, that's just an approximation because we really don't know what the real numbers are. Only the registered numbers with the UNHCR are about 4 million, but that's obviously way underreported. We have discussed this in the last webinar that most stateless persons, a lot of them are simply closeted for fear of being persecuted or deported, etc., etc. So the real numbers are not known. Approximations, of course, are 10 to 13 million, which is significant considering that we have about 25 to 27 million refugees. So it's a very significant number of stateless persons. So this is a list of the 77 countries that are parties to the 1961 convention. And what you will notice here is that most of the countries which are the global hotspots for statelessness today, such as Bangladesh, Myanmar, Thailand, DRC, Zimbabwe, etc. They are not parties to the 1961 convention. The sole exception to that is Côte d'Ivoire or Ivory Coast, which is a party to the 1961 convention, and it is a global hotspot. And of course, the UNHCR has been working quite a lot with Ivory Coast to reduce statelessness. But apart from that, the problem of statelessness is directly a result of non-ratification of the 1961 convention. You could put Dominican Republic also here with a lot of Haitians being stateless in the Dominican Republic. At the bottom, in the blue, are the countries that became parties to the convention since 2015. So these are the recent ones: Italy, Mali, Sierra Leone, Guinea-Bissau, Burkina Faso, Luxembourg, Chile, Haiti, Spain, Angola, North Macedonia. And this year, in 2021, Iceland and Togo are the new additions to this treaty. Now, finally, and I'll stop here with this slide. I'm not going to go too much into depth on the Global Action Plan 2014 to 2024 because it is both part of your readings, but more importantly, it's part of the discussion forums, forum question. And of course, I'll give you extensive feedback on your discussions on the Global Action Plan. But just very briefly to run through these, this was adopted in 2014. We are 3 years away from the end of this Global Action Plan. We are nowhere close to being successful on this Global Action Plan. It probably will need to be extended for a longer duration. But it is ideal that we do not talk about extensions in 2021. Instead, rather, it's important that global attention is focused on trying to make the most of the remaining 3 years by highlighting the urgency of the end of the 2024 plan. So what are these 10 plans? Number one, resolve existing major situations of statelessness. Number two, ensure that no child is born stateless. Number three, remove gender discrimination from nationality laws, including some of the examples I gave you about Saudi Arabia and some laws where nationality cannot be conferred from the mother. Prevent denial, loss, or deprivation of nationality on discriminatory grounds, such as is the case in Myanmar. Prevent statelessness in case of state succession. Sudan, South Sudan, Eritrea, Ethiopia examples. Grant protection status to stateless migrants and facilitate their naturalization. Ensure birth registration for the prevention of statelessness, such as the case is in Afghanistan and Syria today, where a lot of statelessness is simply the result of the conflict and lack of administrative procedures. But it's not only in conflict areas that this exists. I mean, Yemen is another good example, Somalia, but also in many parts where, for instance, indigenous peoples that are remote do not have birth registration documents, right? So provide and take care that birth registrations, which are the proof of nationality, or at least of birth in most cases, and identity is important. Issue nationality documents to those with entitlement to it, accede to the UN statelessness conventions, and improve quantitative and qualitative data on statelessness populations. Because as I pointed out, we are really shooting in the dark with relation to the scale of the problem of statelessness, because we are working with approximations of 10 to 13. We really don't know, what the actual scale of statelessness around the world really is. And if you take into account Afghanistan, Syria, Yemen, Somalia today, we generally don't figure, Yemen, Somalia doesn't generally figure in the hotspots for statelessness in the UNHCR statistics as much as some others do. But it's only logical to believe that, we simply don't have data from these countries that give us accurate figures. Now, obviously, if all these 10 actions are put into place simultaneously, the problem of statelessness will be eradicated. There are issues, of course, with this action plan suffering from non-implementation, of which we will discuss in the forum, and obviously non-ratification, number 9 of the statelessness conventions, are a big challenge also. So I'll stop there with my presentation, and we can open up the floor for any questions or comments that you may have. I'm going to stop the sharing, and let's open up the floor for any questions.
Hi, this is Julia. I have a question.
Yes.
This last topic that you were talking about, it has to do with the I Belong campaign. That's the name of it?
Yeah, so it is the I Belong, hashtag I Belong campaign is what it came to be called as since 2014. That's exactly the global action plan. The I Belong, of course, is a catchy phrase for exactly the same global action plan. And in your readings, I've included recent analysis from the advisor of UNHCR for the I Belong campaign, where she undertakes an evaluation of the challenges, the successes, the opportunities, the prospects of the I Belong campaign and the global action plan, why things have worked, why things have not worked. And of course, all of this is very relevant for the discussion forum. But yes, you're right. It's exactly that I Belong, hashtag I Belong campaign.
Okay, thank you.
Is it only for the countries belong to ratify the convention? Is for global or only?
It's global. Yeah. The hashtag I Belong campaign is global. Two reasons for that. Number one, this is a campaign that comes from the UNHCR, and UNHCR is its mandate for statelessness is not restricted to the Statelessness Convention. Its mandate for protection and reduction of statelessness is global in nature, as I pointed out in the first webinar. So even part of the advocacy and part of the actions that are required to be undertaken under the Global Action Plan or I Belong campaign is getting more countries to ratify the conventions, right? So it's not restricted to only those that are parties to the convention.
Thank you.
Okay, so I do not see any other questions coming up. Julia, Asin, Lara, or Sophia. So probably, if there are none, then probably we can conclude this presentation, this webinar. Yep, I think we can stop it then. All right, see you all. Thank you, and see you all in the next webinar, where we'll be discussing the challenges to the protection of statelessness regime. Bye for now.
Okay, thank you.
Bye-bye.
Thank you. Bye.